welcome you and thank you for the input that you've made on the hate crimes, hate speech bill, as well as accepting to come and make a presentation to the committee. We'll be giving you 15 minutes, and thereafter members would ask you questions for clarity. Yeah, we would prefer it if you could home in on what your issues are with the bill, as well as what your recommendations are. Over to you, Mr. Rosenthal.
Okay, thank you. I'm going to start off just in terms of what I would like to frame as the priority of this bill and the need to deliberate specifically on each of these alternatives and to give due time to that. Then I'm going to give some case examples of people who recently and currently are facing unjust hate speech charges and why we don't want these kinds of things to happen further in South Africa, and even more seriously with the risk of an 8-year jail sentence. And then I'm going to outline some alternatives that can be used to improve this bill if the committee is not willing to scrap it. First prize would be to scrap this bill because I don't see a need for it, but otherwise we'd outline about 20 small changes in text which could reduce the risk of innocent people going to jail or alternatively being made afraid to express their views in the public arena. And then I would also like to rebut a collection of motivations that the Department of Justice has put forward in favor of this bill, all of which I think are flawed and inaccurate and misleading. But just to start off with my request that there is due time allowed for deliberation and that members make use of that opportunity to deliberate on each of those alternatives and participate in that. This is the most complicated bill that I personally have ever seen, and it's also a game changer because it potentially can change the expression of political and religious opinions in this country, which then impact on the actual democracy and all other laws in this country. And so I will go now to a slide presentation with some of these case examples. Firstly, just to introduce, the Association of Christian Media has 70 members that are all involved in either broadcasting or print media in this country, and has been participating in many similar concerns to this bill previously. To give examples of innocent people accused of hate speech, we have firstly a feminist who in the United Kingdom, which I think that the Deputy Minister of Justice framed as a good country, who put up this billboard saying a woman is an adult human female. She was then interrogated by the police and intimidated for several hours. There was also a clash between her organization and a group of trans activists who were biological males, saying that they were female, who argued that this was hate speech. The second example is from Durban. Simeon Chetty is an evangelist who was preaching in the street and arguing why his experience of Jesus was greater than the Hindu gods. This greatly offended certain Hindus who were listening to him and also listened to a video clip on social media of what he said. And they then made civil hate speech charges against him, wanted R1 million financial damages for his comparison. This put enormous stress on him, and in my opinion, that type of action, although it was settled out of court, is with no damages paid, puts enormous stress, and that stress would be much greater if this was a threat of jail for 8 years. The next example is the former Minister of Police, in Finland who is currently on trial for criminal hate speech charges for posting exactly what I've put on the screen here. Her name is Pavi Ransanen, and she was on trial this week. Her sentence will be heard next week, which is actually on appeal because the state was not happy with the outcome of the lower court saying that she was innocent. Now, this puts enormous stress on her. She's actually the leader of a political party in Finland, and to me that is completely unacceptable. That chills the religious and political debate. Another example was a satire, a comedy, which was recently banned on Twitter. There's a politician in America who is biological male posing as a female. The satire group put him as Man of the Year, and that was then judged as hate speech and locked out. Now, all of this would be so much more serious, as is, for example, the Finnish example. I can also give examples. The Prime Minister of Pakistan, former Prime Minister Imran Khan, is currently facing criminal hate speech charges. And I think that the members must be careful not to think just this only applies to other people. It could also apply to you one day in future. To now go to the bill itself, the most complex an important part of the bill is essentially the flow from the grounds to the definition of harm, to the offense, to the exemptions, and then a clause which essentially gives exemption from the exemptions, and as it's worded at the moment, makes the exemptions fairly meaningless and, in fact, in my view, just smoke and mirrors. So I really would like to explain what is a very major flaw with this exemption from the exemptions, in which it is pretending to give protection to religious media and artistic and scientific speech, but it doesn't actually. The question, this table breaks down the different categories of what could be penalized versus not penalized. Now, one's got a supposed exemption from these religious, scientific, artistic, and media criteria, but then at the end of it, it says that does not cause incitement to cause harm. Now, that sounds pretty reasonable if you interpret that harm as physical harm, because we actually don't want to protect anybody from inciting physical harm against other people. It's not necessary, but neither do we want to protect people because there's already other laws that do that. The problem is that harm in this bill is defined very, very broadly, including social, psychological, emotional harm, and economic harm, which can be interpreted to oppose boycotts. And I think that boycotts are an important part of our civil society. So the part that's in yellow is the part that we have a major problem with, which is the exemption from the exemption then takes away the protection if there's an incitement or an alleged incitement towards psychological or social harm that is so the problem there is that if somebody is campaigning for a political or religious cause and the two can opinion, somebody else can say, well, your opinion is causing social harm. And then they can say, well, by campaigning for that opinion, you are inciting other people to do something. For example, if you're campaigning against same-sex marriage or for some cause to say, well, males should only be allowed to go into male bathrooms and females only into female bathrooms, somebody can say, well, that's causing me social harm. So that then can allow this to trigger the thing, and the entire protection of the bill becomes meaningless. So please be aware of that danger. I think that a major proposal that we have put forward to improve this bill, which has already been considered by the National Assembly, but to my unhappiness, it was voted through, and many of the people who voted it through were not present at the deliberations to listen to the reasons why this needed to be changed. So firstly, in the offense of hate speech, remove the words be harmful and just have incite harm. That is in 4.1a. Then in the exemption clause, and this is this exemption from the exemptions problem, is that you change that exemption from the exceptions to only physical harm, so that these other things such as social or psychological harm do not then nullify the exemptions. That's just inserting one word there and deleting two words from 4.1a. Then one can also add in, to strengthen it, in section 4.2, by a religious organization in public or in private. That is because some people may interpret this bill and are likely to say, well, this is only to protect actual evangelism and actual preaching in a church. Now, I don't think that's adequate. I think people who have a religious opinion should be entitled to discuss that in the public arena, on social media, on the radio, in the street, or the newspaper, or wherever they want to. So that would fix that. Then the penalties clause needs to be drastically reduced. You've got in Canada the example of 2 years. Now this is 8 years. The arguments I've outlined in our submission, the reasons why that was proposed in the National Assembly, and the reasons are all flawed. You can see those there. Then in terms of the definition of harm, please to delete this term, vague term, social harm, which nobody actually knows what it means, and the word economic harm, because the word economic harm can then stop boycotts. And I think everybody will agree that boycotts are an important part of our consumer and our political history. So in terms of the grounds, to narrow the grounds, I think, as some of the previous speakers have repeated, to those that are in the Bill of Rights and the International Covenant on Civil and Political Rights, which is really where our Bill of Rights gets that from. Those are internationally tested. The longer the list, the more the risk of problems. But of those rights, the most problematic is this one, gender expression, because that allows somebody, for example, a biological male, to say, well, on Tuesday, I identify as a female. On Wednesday, I identify as a male. It is a completely flexible and undefined term, and that can put people's safety at risk, and particularly people the privacy of spaces and the participation of sports. Then there are a number of proposals that we put forward which could be used to panel beat the definitions in this bill into something which would be less likely to cause problems. Disagree with the previous speaker in terms of the need to define hatred. I think that we can borrow the good parts of the Kwalani judgment to put it into a definition which we have proposed here. This bill will be administered mostly by a magistrate's court who is not going to have the time to go into all of the constitutional court judgments. We want to make this simple so that there can be justice. And we've put forward a proposal there. At the end of our submission in a table, one can also define promote, propagate, or advocate. We can define the public interest as the Film and Publications Bill does. We can define social detriment, although I prefer the deletion of the word social. We can narrow the definition of harm, preferably to remove psychological and all these other things, but if one is going to keep the psychological harm, to make it as strong as possible so that it is gross psychological harm, preferably, or deep, which was the word used in Kwalani. I don't accept the argument that we must just default to Kwalani. Kwalani was a civil case, and it's also a prime example of an actual unjust judgment where the court did not make a finding that was logically consistent with its own reasoning, to the particular facts of the case. So we want to make this simple because people get emotive when there are hate speech cases, and we want to reduce the risk of innocent people going to jail, which could be you and me, or being chilled from expressing their viewpoint. Then the regulations, I would request that they be put a qualification that they put out for 30 days for public comment, and that the holiday period is not counted in the reckoning of days. That would substantially reduce the risk of problems there. Sorry, is there?
Are you done, Mr. Are you done?
Yes, well, I'm happy to carry on talking, but I've done my 15 minutes. So with respect, unless I have permission to carry on, then I have to ask you permission. But I'd love to carry on.
Hello? I'm saying we you can.
Sorry, Chair, you're not audible.
Continue.
We can't hear you, Chair.
Perhaps till about 20 minutes would be okay.
Okay, thank you. I would also just like to address the question raised by Mr. Mikolakis with respect to the exemption for religious groups. I would disagree with the answer of the previous speaker. I think that the exemption for religious reasons
Can you hear me now?
Is part of the separation of church and state. It's a part of Western culture and historic law for the last about 400 years, and parallels the importance of the protection of the media and science. One can consider broadening the protection for other people, but I don't think we can consider narrowing the protection for people who motivated in grounds of conscience. We've got a long history of people going to jail for expressing their religious viewpoints over hundreds of years, and that is essentially what shaped our constitutional democracy, was the need to protect those freedoms. The first person who proposed even the idea of freedom of speech, his name was Pastor Helways. He spent the rest of his life in the Tower of London under James I. We don't want to go back there, and so I think it's critically important to keep that. Then, in terms of these claims that this is motivated by international law, the International Covenant on Civil and Political Rights has only 3 grounds. It doesn't say we must criminalize it. We've already fulfilled our obligations there. The South African Parliament has not ratified this covenant. Also, this rebut plan of action on hate speech, this bill does not fill or comply with those requirements. The European guideline policy documents, which are not international law, this has been selectively quoted by the Department of Justice. It does not fit with these European guidelines, which also give balancing requirements. The claim that this is required by the Bill of Rights is false, and I think the criminal law is going to require a much higher standard than the civil law under the Equality Act. Further than that, this claim that it's required in terms of this covenant on combating racism, that is one select ground which is not controversial. It's this which is already unprotected in the Bill of Rights. What we are concerned about is this collection of other rights, which is likely to that's been added to the grounds, which is likely to lead to more conflict. Then further, if one looks at the statistics of the actual countries which the Department of Justice has itself used in its motivation documents, the homicide statistics did not come down as a consequence of hate speech laws. In some countries, they actually went up, or alternatively, they were part of a long-term downward trend over a long period, and no change is shown by the institution of the law. The one thing which has happened in these countries is the chilling effect, that people are then afraid to express their opinions on controversial issues, and that affects the freedom of the media, it affects the freedom of religion, and it benefits the most aggressive activist groups who continually lodge charges against other people, saying that who have a different view, then saying that that is hate speech. So I would argue that all of these are flawed, and we've put more detail in the submission on all of those questions. And so I would ask, first prize, don't pass this bill. Second prize, to make these changes which would reduce the risk of innocent people going to jail. So I've used my 20 minutes. Thank you.
Thank you very much, Mr. Rosenthal. My apologies. I seem to be having network problems yesterday and today, but yeah. I see you've also ventured into some questions that members would have probably asked, but let me allow members to ask you questions first. Are there any questions that honourable members would like to ask? I think Mr. Rosenthal actually ventured into that aspect as well. But yeah, honourable members. Okay, I don't see any hand. Can you hear me, Mr. Rosenthal?
Yes, I can, yeah.
Oh, you can, great. Okay, I'm just worried. All right, no, it's fine. I think you ventured into some of the issues members would have probably asked questions about. So I think members are fairly well covered. But let me take this opportunity to thank you for your input and for your presentation. Yeah, thank you very much. I think our session with you is actually done.